Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jacqueline Phillips, and today's episode is Back to Form or Back to the Drawing Board, how to navigate the decision vacating the new HSR rules. In February 2025, Judge Kernodle of the Eastern District of Texas vacated the Federal Trade Commission's recently updated rule concerning pre-merger notification requirements. Just 1 year prior, the rule in its current form came into effect, and it significantly expanded the information merging parties were required to include with its filings. Now, just as companies and their attorneys are getting acclimated to the new requirements, the future of the rule and the scope of pre-merger notification requirements are in limbo. We're recording this episode on Wednesday, February 25th, 2026, and we'll discuss where things stand as of today, where they're going, and tips for navigating ongoing uncertainty. I'm here with my co-host, Lexi Michaud. Hey, Lexi.
Hey, Jacqueline.
Can you introduce us to today's guest?
Happy to. So today on our Curious Amalgam, we are joined by Daniel Rosenthal. Daniel is a partner at Kirkland & Ellis, where he is based out of the DC office, and he's a part of the Antitrust and Competition Group. Daniel has extensive experience advising on complex merger reviews, antitrust enforcement matters, and he works with clients across various industries from healthcare, pharmaceuticals, biotech, manufacturing, and oil and gas. Among the topics Daniel advises on is the HSR Act, which we're going to talk about today. And Daniel was actually a guest on our Curious Amalgam in 2024, where we talked about the new rules that came into effect in 2025, the new HSR rules, on an episode called Are You Kidding Me? Unpacking the new requirements for merging parties in the U.S. Welcome back to the show, Daniel.
Very nice to be here. Nice to see you again, Lexi and Jacqueline.
All right, Dan, I remember that episode well because I came up with that clever title. So it wasn't that long ago that you and I were having a similar conversation. So before we get into why you're back with us, which we're very, very glad to see you and have you, let's quickly just back up. As Lexi mentioned, you discussed HSR rule changes on your prior episode with us. So quickly tell us what happened then and what changed at that time.
Yeah, it's a bit of Groundhog Day, right? I mean, there's a lot of work to get me back on a Curious Amalgam, but I'm happy to be here. Yeah, so we had a great conversation a little over a year ago, back in October of 2024, and the reason that we were talking at that point was prior to that, the HSR Act has had a filing regime that's been largely, there's been some updates, but it's been largely unchanged for about 40 plus years since the 1970s. There'd been some updates to it, but no wholesale large updates to the filing requirements under the HSR Act. In 2023, there was a notice of proposed rulemaking in which the agencies, the FTC and the DOJ, proposed far-reaching changes to the way filers would need to collect information and the type of information and data and documents that would need to be produced for the filing. Importantly, though, and I know we talked about this before, there's no changes to the types of transactions that require filings. And we'll talk about that on this program. Nothing we're about to talk about is going to change that. But the filing itself, the proposal was to change it pretty significantly. There was a fairly broad notice and comment period where over 700 commenters wrote in talking about those proposed rules and weighing in on the aspects that they liked and the aspects that they thought were not going to be conducive to having an efficient process. And in October of 2024, the final rules were announced. And that is, I think we recorded, they were still hot off the press when we recorded last time, but those final rules were announced in October. And over the course of the next few months, those final rules were ultimately implemented in February of 2025.
Thanks, Dan. Yes, they absolutely were. I remember you had just taken the time to go through them as quickly as you could so that we could update our listeners on what that final rule looked like when we recorded. And before we get into what's going on today, I mean, this is what you do every day for your clients. Do you think that over the past year, there has been some acclimation to these new rules and that companies are starting to get into a groove of what's required?
Yeah, it was a process both for firms and practitioners to get accustomed to the new rules, to understand the new guidance that was coming out, to make sure that everyone was applying those new rules correctly. But especially for parties and for filing parties and clients, understanding the scope and breadth of those new rules did take some time. I know that many folks, including myself, did many presentations for clients explaining what was changing, what was staying the same. So I think that there's been some challenges, but like anything else, you get accustomed to things over time. And I do think over the past year, filing parties have gotten generally more accustomed to the types of information that they're going to need to pull for filings. It's certainly taken more time, and I think that what we're going to talk about that, and that's a core aspect of what's in dispute in the Eastern District of Texas. The actual costs and the benefits that inure from those costs. But filing parties, I think, have largely started to settle in.
So, I'm hearing that there was a lot of work that went into advising companies on what these rules were going to look like, starting to get used to how they changed and the time that was coming into it. And then we're here today talking about some limbo that these rules might be in. So how did we get here and what's going on?
Yeah. So I do think that you're right that filers are getting used to. I wouldn't say they're enjoying or every filing is smooth sailings, but at least you start over the course of a year, you get more accustomed to the type of information that's going to be required. In January, so a month before the new rules were enacted, several major business groups, including the U.S. Chamber of Commerce, the Business Roundtable, the American Investment Council, and the Longview Chamber of Commerce down in Texas, they filed a lawsuit in the Eastern District of Texas challenging the FTC rulemaking here and effectively trying to enjoin the rules from coming into effect, but then also to get a ruling that the rulemaking was unlawful and therefore the final rules are null and void.
And now we have a decision from the court. So can you give us the details of that, Dan?
Yeah, and I must admit that you get focused on what you're doing, and so was certainly aware of this lawsuit that was percolating through the system, but it certainly was not, at least for me, candidly, top of mind. I don't think we were, waiting with bated breath on a daily basis for when this ruling was going to come down. However, a few weeks ago, and as Jacqueline, I know you pointed out at the beginning of the taping here, we're taping this in February. So we may either look, quite prescient or a little silly if we find some things out before this hits the internet. But on February 12th, the Eastern District of Texas issued its ruling. It granted summary judgment to these business groups and against the FTC, saying that the rulemaking was improperly done. And we can talk a little bit about what the actual ruling stated. But effectively, the outcome of that was that the Eastern District of Texas vacated the new HSR rules, such that based on the decision of the district court, the HSR rules would be null and void, and we would go back to the prior rules that were in effect before the new rules were implemented.
Can you tell us a bit more about the reasons why the rule was vacated?
Sure. So when you have major rulemaking, the rulemaking needs to be done in accordance with the Administrative Procedures Act, the APA. And under that act, it sort of governs whether that rulemaking is deemed to be unlawful or doesn't follow the proper protocol. Here, Judge Kernodle in the Eastern District of Texas found that the FTC exceeded its authority in drafting and finalizing these rules because primarily he said that under the HSR Act, the rules need to be necessary. The information to be gathered by those filings needs to be necessary and appropriate for the scope of the law. And what Judge Kernodle said in his opinion was that really that the FTC did not adequately explain how the added costs that are placed on all filers as a result of these new rules, how those outweigh the benefits of the new rule would outweigh those costs. He focused a lot on the fact that even by the FTC's own estimates, the time it takes to put together an HSR filing more than triples. The costs were materially higher. The Chamber of Commerce and the plaintiffs here thought that was still a gross underestimate of the amount of time required to do these new filings. But the judge was persuaded that the FTC had not met its burden of explaining why those benefits outweigh the cost. One thing that the opinion points out is that the FTC did not identify a single instance of an unlawful merger that would have been blocked had the prior HSR form included the information that the new form has. And he found that to be quite persuasive to show that the new rules were overbroad. He also pointed out that as of a few months before the new rules were announced, the FTC had on its website talked about how effective the HSR filings are for identifying potentially anti-competitive transactions. So the judge was quite a strong opinion, saying that the FTC had not met its burden and that the HSR rules needed to be vacated.
Dan, can I quickly ask you a quick question about that? So we talked about the decision, summary judgment was granted, the rule is unlawful according to the district court judge. Am I right that the Fifth Circuit currently has a stay in place so that even though it has been ruled unlawful, we're not reverting? Is that where we stand procedurally?
That's exactly right. So where we stand procedurally is under the Eastern District of Texas's order, Judge Kernodle issued a 7-day stay, allowing the FTC to appeal to the Fifth Circuit. They ultimately did appeal to the Fifth Circuit. The Fifth Circuit issued an administrative stay, basically, halting or pausing the ruling of the Eastern District of Texas until they had a chance to opine on whether to extend the stay pending the outcome of the appeal. That's where we're at procedurally right now. The motions panel is reviewing briefings from the party actually this week as we discuss. And it's likely that we will get a decision in the near future on whether they plan to either grant the stay, which would keep everything paused until the Fifth Circuit ultimately reaches a decision on the appeal. Now, that is a process that can take some time. I think typically Fifth Circuit appeals take between 9 and 12 months or longer to reach a decision. So that would be a fairly extended time where we would be still operating as if nothing happened, really. I mean, we would still be operating under the new rules. So that's one option. Another option would be they deny the stay. And in that scenario, I think we would expect that the FTC would issue instructions pretty quickly on exactly what form parties should use to make their filing. But in that instance, it would be pretty quick that we would sort of go back to the old regime, the old filing regime. At that point, and it's speculative. I think the FTC would have a decision on their hands about whether they want to continue with the appeal, given the length of time it would take to reach the ultimate conclusion here, given the fact that we would be back in the old filing regime for that period of time. And the third option, which is, maybe a little wonky procedurally, but the third option is that the motions panel, the three judges that are deciding this stay, would ultimately punt that decision to the arguments panel, the panel that's ultimately deciding the appeal. We wouldn't get a decision on the stay. The administrative stay would be extended for a period of time, and we would still be in this sort of state of limbo. And then the merits panel, the argument panel, would ultimately make a decision about whether to maintain that stay for the pendency of the litigation.
So it sounds from your explanation, your very clear explanation there, that merging parties are facing a lot of uncertainty at the moment. It feels like, as you alluded to earlier, we're finally getting our footing with the new rules. Companies have reorganized how they're collecting and maintaining information to respond to the new form. And now we have a stay. So can you tell us a bit about how you are advising clients in this interim period when we have all this uncertainty?
Yeah, absolutely. And it's a really important point. So I'm sure we have uncertainty in terms of where things are going to land for the long term. But in the short term, I think filers and clients, the important thing to remember is right now we should just, business as usual is paramount. Filers should continue to collect information under the broader new rules filing regime. I'm advising my clients that until we hear otherwise, we really need to continue to plan for filings, in a similar fashion that we've done over the past year. The one thing I will say is that, there is some benefit, certainly, and I think we can talk about this in more detail about what the world would be like, right, if we did have to go back to the old HSR form. But there's a couple pieces of information where certainly I think if a client wants to really get ahead of things and be able to pivot very quickly to the new form, they could collect certain discrete pieces of information now. And, I'm happy to elaborate on that if desired. But really, I think for now, the key is nothing has changed. Filers still need to submit filings under the 2024 new HSR rules. And until we hear otherwise, that's what everyone needs to focus on.
So we touched on this a little bit, but there's a world in which sooner or later we revert back to the old form. We don't know if that's going to happen, of course. And point taken, Dan, everyone needs to be operating on what the current requirements are. If that happens, what should companies be thinking about if they need to make HSR filings?
Yeah, and one thing that I did want to point out is just, as we're sort of in the as practitioners, we are reading the tea leaves, right, in terms of trying to understand and assess risk and try to plan for the future. This, and I know we've already talked probably, maybe too much about this potential stay, but it's very important given the fact that this is going to impact what's going to happen over that, potentially the next year or longer. One thing that I did want to bring up is that the administrative stay was issued by a 3-judge panel on the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals is known for being a more conservative circuit in terms of its posture, and 13 of the 17 judges on the Fifth Circuit Court of Appeals were appointed by Republican presidents. With that in mind, the 3-judge panel that is likely to decide this motion, 2 of the 3 judges, Judge James Graves and Judge Dana Douglas, were appointed by Democratic presidents. Judge Graves was appointed by President Obama. Judge Douglas was appointed by President Biden. Now, we have to be careful not to assume an outcome based on, who appointed a judge, and I'm not suggesting that we should do that, but I do think that if the FTC was going to pick a panel, it wouldn't be upset with this particular panel deciding this motion, given some inherent, maybe perhaps greater skepticism among some of the more conservative judges about regulatory rulemaking. So I think that is something at least to sort of think about. And to your question about what we should plan for under the old HSR rules, under the new rules, there was a significant expansion in terms of the data and information that needed to be collected and produced by companies. I won't go over all of it. We can, I'll plug our last podcast where we go into that in a little bit more detail. But some of the more key items in under the new rules are, officer director disclosures, disclosures of certain ordinary course documents, like what are known as plans and reports that were not prepared for a transaction. The addition of an individual custodian known as the supervisory deal team lead that you have to collect documents from. There was, I think, 20 different categories of new information. Many of those categories of information are not required under the old HSR filing. So a party would not have to submit information on that, at least as part of the initial HSR filing. That being said, there were a few discrete sort of, counterbalancing piece of information that were taken out of the old rules and not included in the new rules that if we did go back to the old rules, we would have to go back to using. Two of the more important ones are the inclusion of what are known as NAPS codes, which are product level classification codes. Those were eliminated as part of the new HSR rules. So if we went back to the old rules, we would have to identify and allocate revenue information based on NAPS codes for certain transactions. The other piece of additional data that would need to be collected is under the new rules for NAICS codes. And I know a lot of acronyms right now, but for NAICS codes, under the new rules, we only have to identify revenue by band. So in a less specific manner. The old rules, it was more specific. You had to identify, actual revenue allocation by NAICS code within a tenth of $1 million. So it's quite a bit more specific. So there is some information that would be in the old form that wasn't in the new form. So those are the pieces that I alluded to, that if a party really wanted to get ahead of things and be really prepared, they could start, making sure that they have revenue information by NAICS code in a more granular fashion and dust off the NAPS codes they have. Under the old rules, timing for HSR filing was not always, but oftentimes, 5 business days, 10 business days was more the norm for the timing that was allotted to parties to prepare their HSR filings. Under the new rules, that time has been extended because of the additional burden and the additional quantity of data and information. So under the new rules, it's oftentimes 20, 25 business days. So, under the old rules, I think that we would have potentially have a pullback in the timing provisions that we see in agreements.
Got it. That's super helpful. I think everyone thinks about the new rules as having more and the old rules have less. So knowing that there's some differences there and keeping the timing in mind before the filing when you're negotiating your merger agreement is really important to keep in mind. I have one more question about this before we do our fun end segments that just occurred to me. I work a lot on non-compete issues, and we just saw the FTC be very against the rulemaking that the FTC under the prior administration had put forward and did not support the non-compete rulemaking on appeal and are moving forward with enforcement in that realm in other ways. Here, this rulemaking started under a different administration. Is it still being supported? So when companies are thinking about their risk analysis and what might change right now, do we expect that the FTC will continue to legally fight for this rule?
Yeah, it's a great question. And I think candidly, there was some internal I know that just in discussions that I've had, it was not entirely clear that the FTC would appeal the Eastern District of Texas decision to the Fifth Circuit. And I think for that very reason, I mean, if you go back in time, one of the interesting aspects of this particular rulemaking is, even though it was proposed and negotiated under the prior administration, when the rulemaking was announced and finalized, it was unanimously supported, and that included all 5 commissioners. And at the time, there were commissioners from both Democratic and Republican commissioners, including Chair Ferguson, who was one of the individuals who concurred with the final rules. And if you looked at his concurring statement at the time, he indicated, I think, candidly, was that, if he could have, written the rules himself, he probably wouldn't have included everything that went into the final rules, but it was the culmination of a compromise approach. And that, I think that was very telling when you saw all of the aspects of the proposed rule that didn't make it into the final rule. So, I think that Chair Ferguson's concurring statement is pretty illuminating in this regard. And he also pointed out in that statement about why he thought that the FTC was within its lawful authority with this rulemaking. And he explained that in pretty significant detail in his statement. So I think that it seems clear that at least up until this point, the leadership of the FTC is in support of the expanded HSR rules that were brought into enforcement in 2000 and in last year in 2025. However, I think this is a fluid situation where it would be hard to forecast exactly what they ultimately will want to do here, given the fact that we are in a very different landscape now than we were in October 2024.
If I can ask you a quick follow-up question to that, is there a world, do you think, in which if the rule ultimately does get struck down, the FTC revisits a scaled back version of the rules? Or is this the end of, large scale reform to the HSR form for a while?
Yeah, that's a great question as well. And I think the answer to that is yes. I think that if the final rule, the 2024 rulemaking is vacated, it would certainly not surprise me to see that the FTC Chairman Ferguson propose rules that may provide some of the benefits that I think he alluded to and others have alluded to from the changes to the form, and perhaps mitigate or minimize some of the costs that the court pointed out as being, as outweighing those benefits. I think that, that would require most likely another notice and comment period. So it would be an extended process. It's not something we would see overnight where they can simply, implement a new form. It would go through a extended process. But I do think that there's a strong likelihood that we would see additional changes. And on that note, and it's a really good point, there was, and this is, a bit nitpicky, but it is important, is that there is one aspect of the new rules that was, one aspect of the new form that was not promulgated through this rulemaking. And that has to do with the requirement to list foreign subsidies of governments of concern, as it's known. These are certain subsidies from countries like China and Russia and North Korea and Iran. That was a requirement that came from a different law that was passed by Congress, the 2022 Merger Filing Fee Modernization Act. So there's a separate congressional requirement to have that information included in an HSR filing. Right now, if the new rule is vacated, I think it's a bit of an open question for how the FTC is likely to get that information. They may ask for it voluntarily. They may issue voluntary access letters. But until they update the form, if we go back to the old HSR form, I think it would be challenging for them to add it as a required aspect of the form that needs to be certified to.
Well, thank you, Dan. This was a ton of really helpful information on what's going on. And I think that regardless of what happens after today, you've given everyone a lot to think about and prepare for as under any circumstance that we might see. So really appreciate you coming back. Maybe mark your calendar for 2027 when we get a decision from the Fifth Circuit. Lexi and I will be right here ready to talk more. But before we let you go, we're going to do our usual. We know from the last episode that Halloween 2025, you were slated to dress up as a dinosaur during Halloween. Today, we need to hear something different about you that we don't know from working with you.
Yeah, the dinosaur was a I wouldn't say it was a big hit, but it successfely did that for Halloween. So
was it inflatable? Was it inflated? Or
it was not. It was not. My kids have changed. I know that Jacqueline, you have kids as well. My kids changed their mind about Halloween costumes on a moment's notice. So I didn't know that until October 31st that was going to be the costume for sure. Okay. But I think that if we were recording this from my home office, you'd probably see behind me. You'd see pretty quickly that two of my passions are I enjoy woodworking when I'm not playing with my kids. So you'd probably see something that I tried to at least make with my hands on woodworking. But you'd also see my passion for the sports teams that I love. One of which is UVA, all things UVA, basketball, football, etc. And that has brought me some joy, some sadness, but some joy over the years. And then there's the New York Jets, which has brought me nothing but despair and sadness. So I'm going to blame my brother. If you're listening to this, it's your fault that I've had a lifetime of disappointment in my professional football team.
And now it's time for the Curious Hat.
Dan, I have one more question for you before we wrap up. And my question for you today is, what is one job that you would be terrible at, but that you would still love to try for a day?
Wow. It's hard because I would be so bad at so many jobs, but maybe this is a cop-out because I said woodworking, but man, I would love to just for a day, basically be the right-hand man for, an electrician or a plumber. And I don't think I would do particularly well in it, but man, I think it would be super interesting. And I think I would learn a lot, and maybe I'd be able to fix my toilet if it breaks without calling someone next time. So I don't think I'd be particularly good at it, but I would certainly welcome the opportunity to be an apprentice for a day.
Well, plumbing is not where I thought you were going to go with that answer. It's a good one.
Hey, it would be a great money saver if you could do those things around the house yourself. I'm sure your wife would really appreciate it.
Well, like anything else, it starts off as a money saver, but then it becomes a money pit when you can't do it correctly.
Yeah, when you break everything.
Yeah.
All right, Dan. Well, thank you again. And thanks to our listeners. We'll keep you updated if we hear anything more. So I'll see you next time on our Curious Amalgam.
Thank you so much. Appreciate it.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.